Judgment in the appeal, the Queen on the application of Modaresi against the Secretary of State for Health.
Lord Carnworth will give the judgment.
Mrs. Modaresi, who suffers from schizophrenia, was detained for assessment under Section 2 of the Mental Health Act 1983 on the 20th of December 2010. She had a right to apply to the first-tier tribunal within 14 days to review her detention. Unfortunately, due to an oversight within the National Health Trust over the New Year period, her completed form was overlooked, and it arrived in the tribunal's office a day late, and it was rejected on those grounds. There was no appeal against that rejection. By that time, her status had changed because she had been detained for treatment under Section 3. That gave her a new right to apply to the tribunal. However, she was concerned that if she exercised that right rather than going under Section 2, it would limit her opportunity to apply in the future if circumstances change. Instead, she asked the Secretary of State to exercise his discretion under Section 67(1) of the Act to refer her case to the tribunal, which he refused. She began judicial review proceedings against the Secretary of State, the Trust, and the tribunal. Shortly afterwards, she was released under a community treatment order. Her claim for judicial review was dismissed by the High Court and the Court of Appeal. By the time the case came to the Court of Appeal, it had become clear that the tribunal had been wrong to reject her application as out of time. The authorities show that when an act prescribes a period for doing something which can only be done on a day when the court office is closed, the time is extended to the next day on which it is open. Her appeal to the Supreme Court is unanimously dismissed, the reasons given in a judgment given by me. Mrs. Modaresi was not deprived of her right of access to a court or tribunal to review her detention. She had such a right under Section 3. There was no evidence that the intervention by the Secretary of State under Section 67 would have secured a more speedy hearing than a request by her solicitors direct to the tribunal for expedition. As to her circumstances changing so as to justify a further application to the tribunal, that was covered by the Secretary of State indicating his willingness to consider a reference under Section 67 if it became necessary at that stage. The error of law, which was shared by everyone initially as to the operation of the time limit, did not provide a reason to set aside the Secretary of State's decision. In a concurring judgment, Lady Hale added that Mrs. Modaresi had been let down by the system through no fault of her own. The hospital's failure to transmit her application to the tribunal deprived her of the right of access to a tribunal which the law provides and might have led to a breach of her convention rights. The only safe course for trusts in such a situation is to have a system which ensures that this does not happen.